In particular, as I said, we welcome greatly the comments made by all of these legal luminaries. I am quite heartened by the statements of my professor in constitutional law, Justice B.B. Mendoza, who in my freshman year taught me the rubric of constitutionalism, and in particular, I'm very happy that he said that what has been done is to bring this draft to be in conformity with the Constitution. Nonetheless, he did raise some issues, and these are important, valid issues, particularly issues focusing on the elements of the state, which I hope to address. But thankfully, my colleague in the Constitutional Commission and his colleague in the Supreme Court had already addressed many of them, and I just wish to echo the statements made by Justice Ascuna regarding the spirit behind the Bangsamoro Basic Law as being consistent with the provisions in our Constitution with reference to autonomous governments. I think that is how Congress will ultimately approach this issue. The Constitution clearly mandates the establishment of an autonomy for the Muslim communities in Mindanao. The extent of that autonomy is within the plenary powers of Congress to establish, subject to the provisions provided in the Constitution itself. Thankfully, our friends from the Philippine Bar Association, as well as my dear friend Dean Lavinia, have said nothing in the draft Bangsamoro Basic Law is patently unconstitutional. If there are issues and concerns that have been raised and could be raised, we defer to the collective wisdom of Congress and its ability to address those concerns, particularly because this esteemed committee itself is ably led by an acknowledged and respected constitutionalist himself, Congressman Rodriguez, who has already written many books on constitutionalism. So we are assured and secured that whatever issues regarding constitutionalism would be addressed by the time this is presented to plenary. Nonetheless, let me address a few of the issues that have been tabled in the course of the discussion. First of all, in respect to the idea or concept of territory as part of the Bangsamoro, there is nothing inherently wrong with referencing territory for a political subdivision of the Philippine state. In fact, Section 1 itself of Article 10 of the Constitution begins with the phrase that territorial and political subdivisions of the Republic of the Philippines are provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao and the Cordilleras as hereinafter provided. So whatever concerns that may be raised regarding defining a territory for the Bangsamoro should not be seen as a pretext to the establishment of a separate or independent state. In fact, it is in the order of things to clearly define what shall be included in the Bangsamoro and what shall not be included in the Bangsamoro. And the only way we are able to do that is to define with some certainty and clarity the issue of territory for the Bangsamoro. Hence the issues raised earlier by Dean Lavinia about plebiscite. Second, with respect to the right to self-determination, as has already been acknowledged in our discussions, the right to self-determination is a fundamental human right acknowledged in many United Nations documents. And the Filipino people also exercise on a regular basis the right to self-determination. For example, when we had ratified this Constitution itself, that was an exercise of the right of self-determination. In the same breath, what Congress is currently contemplating when it is discussing the Bangsamoro Basic Law is to establish as provided in the Constitution, an organic law for the autonomy of Muslim Mindanao. And necessarily, unlike other legislation, whereby the mere act of Congress is sufficient to make it effective and to enable it, with respect to an organic law, after the act of Congress, there must be a plebiscite that will be conducted. And that is what is contemplated to be the right of self-determination for the people in the area of the Bangsamoro when they exercise their right to say yes or to say no to the organic act that will be proposed to them. So there should be no fear about the notion or idea of self-determination as such, because it has already been expressed very clearly that self-determination has two senses. One is external self-determination, where peoples are able to declare themselves independent. But there is also the same notion of self-determination, which is internal in character, where people are from time to time consulted, as in a referendum, within the framework of established political territory like the Philippines. And it is very clear from the preambular statement that what we are creating for the Bangsamoro must be and will be consistent with the Constitution itself. So there should be no fear about the people's exercise of self-determination in the aspect of the plebiscite for the Bangsamoro. That also will deal with the issue of people. But there was a notion raised earlier that what we are providing with the Bangsamoro Basic Law is an opportunity for the people in the area to exclude other persons who may not ascribe or self-ascribe themselves as Bangsamoro, but are found within the territory. There is nothing in my cursory review of the Bangsamoro, the draft Bangsamoro Basic Law, that actually authorizes this distinction between those who ascribe themselves to being Bangsamoro and those who do not, but are found within the same territory. Everything in the provisions of the Bangsamoro Basic Law affirm the rights of all citizens. And so there is no creation of a two-tier system of citizenship within the Bangsamoro framework. What it does say, however, is that the Bangsamoro shall have an opportunity for self-governance by way of the establishment of a political entity, the Bangsamoro government, that will govern themselves from day to day. But who shall govern the Bangsamoro? All those elected by all citizens in the Bangsamoro, whether they ascribe themselves to be Bangsamoro or not. And in fact, there is nothing in the Bangsamoro, draft Bangsamoro Basic Law that says only Bangsamoro shall be entitled to be elected to the Bangsamoro. So again, it's important to highlight that what we are doing is creating a system of self-governance for an area of our country that has been neglected historically, to give them an opportunity to catch up. And that process must be and will be inclusive, as has been expressed already here. Now, let's deal with the issue of whether it is possible to form a ministerial form of government within an essentially presidential and unitary form of government. If we look at the provisions of the Constitution itself, with regards to autonomous regions, we shall see that the authority and latitude to Congress as to the form of government has been given. It says in Section 18, the Congress shall enact an organic act for each autonomous region. That organic act shall define the basic structure of government for the region, consisting of the executive department and legislative assembly, both of which shall be elective and representative of the constituent political units. That is what is stated in Section 18 of the Constitution. It says that the basic structure is up to Congress to establish. So can it be contemplated that a ministerial form of government might be authorized by Congress for the Bangsamoro? We suggest that that is possible. Because even in a parliamentary system, there is still a clear distinction between an executive branch and a legislative branch. The only difference being that the executive department in a parliamentary system is under the control of the parliament, of the parliament in that structure. So it is once a government is constituted by the parliament, that executive department is separate and distinct from the legislative assembly that has been elected. So what we are providing in the Bangsamoro Basic Law is a system of constituting first the legislative assembly or the Bangsamoro Parliament. And then we are further providing the system by which that parliament will elect its chief minister and its cabinet, which will form the executive department. Now the Constitution says both of which shall be elective. And my dear friend, Justice Ascuna has already mentioned, in both instances, this is the case. The legislative department is elected directly by the people, while the executive department of this ministerial form shall still be elected. In fact, there is a specific provision in the Bangsamoro Basic Law that the chief minister must be elected by the parliament. So there is still a system of election that is well established. And so there should be no concern about that. Of course, this is an innovation. We have never tried this before. And certainly there will be issues raised, eyebrows raised, questions raised, and ultimately this will have to be resolved. First, it will be resolved by Congress and perhaps possibly, hopefully not necessarily, issues raised to the Supreme Court. But we don't, if Congress, as it is doing, is already buckling down to resolve all of these issues, there should be no worry about whether or not these issues will at all be raised before the Supreme Court. And if they were, we are ready to defend them rigorously. On that point, I think it's important to reiterate what our friend from the Philippine Bar Association said. It's really a matter of perspective about the Constitution. How do we wish to look at the Constitution? Looking at it broadly and liberally, or restrictively and conservatively? The Bangsamoro Basic Law provides an opportunity for Congress to expand our constitutional frame. The former president of UP mentioned, welcomed this initiative as a necessary first step towards moving towards a federal system of government. That may be so, but we will have to cross that bridge much later, because the Constitution did not establish a federal system. It established a unitary system. Yet, while it established a unitary system, it did mandate autonomy. And therefore, even without constitutional change, it is very well possible to establish an expanded autonomy that we have never achieved thus far for the Bangsamoro, far more than we have given under the Autonomous Region of Fasta Mindanao 9054, but certainly not the doomsday scenarios of an independent, separate state. What we need to do is to work together to bring life to the Constitution. The American Constitution is over 200 years old. Many of the manner and operations of how the U.S. government operates today were never contemplated by that Constitution written 200 years ago. But the reason why that Constitution has remained endearing and enduring is because of the flexibilities provided by that Constitution. There are also flexibilities, particularly with respect to the Bangsamoro, to autonomy, that this Congress can work on. One such issue that has been tabled here, I think both by Justice Ascuna and Dean Lavinia, is the issue of defining for the first time what contiguous areas are. Justice Ascuna mentioned safety clause. He said, those who vote no shall not be included. But the issue we are grappling with is what to do with those that vote yes, but are outside the core territory. This is an important innovation that we must address, and ultimately, I think Congress is in a position to find a way to make a distinction between the reference to contiguous areas, which is particular to autonomy. It is found in the section on autonomy of the Constitution, as opposed to the general provisions that talk about provinces, cities, and municipalities. There is no reference to contiguous areas there, even though there is reference to contiguous areas in the reference to autonomy. So what the challenge is, of course, is to provide a definition. And I agree with what Dean Tony Lavinia is suggesting. If there are issues or potential landmines, what Congress could very well do is relate those references to asymmetry, to contiguous area, or so on, to specific provisions in the Constitution. And I think in that way, we will avoid many of the potential landmines that we are concerned about. Thank you very much. Magandang hapon po sa inyo lahat.